le Premier ministre ne nous dira pas le contraire. Having a large number of people in a society, Karishma Biari exactement, pour avoir donné, pour avoir commenté sur l'état de santé, liberté d'expression, c'est eux qui vont nous donner la leçon aujourd'hui, Monsieur le Président. Alors je disais, having a large number of people in a society who are misinformed is absolutely devastating and extremely difficult to cope with. This is a comment made by esteemed Professor Stefan Lewandowski of University of Bristol when he was speaking about how to tackle misinformation. In a study carried out in developed countries, the data revealed that 64% of adults were of the opinion that made-up news stories were causing confusion about the basic facts of current issues and events. For example, during the weekend, there was a rumor that went viral on social media and eventually was relayed in the news. A minister's daughter at the airport. Fake news, Mr. Speaker, sir. Where was the fact-checking, the evidence? No, Mr. Speaker, sir. Relaying that palab was more important. But what about the reputation of the individual? What about justice? I hope, and I sincerely hope, that the DPM will seek legal redress. And those who are outside just now trying to create havoc, yesterday been walking around and trying to, with all kinds of change, you thought it was like just unleashed from Jurassic Park with all the chains around their neck. They are trying today to tell you that we are going into a dictatorship. You know why they're afraid? Because it is the same people who will go out on the internet, post some fake news, which will be then relayed by some private radio. And here, I think of my good friend, Minister Lejonga and Minister Padayati. Yes, they were sick. They were at home self-isolating. And what the news goes about? They are in ENT. Have they thought about 1 second? They have mothers. They have children abroad. What has been the impact on those people? Is this tolerable? Shouldn't there be some minimum of fact-checking because just going live and reporting a minister is in ENT? And we know how they put the question. We know how they do it. Est-ce que le ministre est ENT? Point, point, point. And how the people read it there? How the people listen to it there? What do they understand? They don't read the question. They take it for a fact. Mr. Speaker, sir, working out who to trust and who not to believe has been a facet of human life since our ancestors began living in a complex societies. In today's modern information age, it is paramount that we ensure that those responsibilities of disseminating information that is done in a very responsible way. This does not mean not to criticize or not to voice our opinions. It does not mean that any government of the day will dictate what is being said. Far from it, Mr. Speaker, sir. The role of our media, especially our radios, is to keep us, elected members, sober and responsible. We agree on this. But, Mr. Speaker, sir, who keep them sober and responsible? We heard it yesterday on radio. One of the presenters was constantly interrupting the Attorney General when he was intervening. Leading questions. Almost like, yes, insolent à la radio. But you know, Mr. Speaker, sir, when one of the opposition members, namely Mr. Honorable Boda, was intervening, and he was going, Winandu, Winandu, Winandu. This is what we were hearing. Is this partiality? If this is not partiality, then what it is? Mr. Speaker, sir, we need to ensure that we have a way to know what we hear is trustworthy. It is actual truth and not manufactured alternative facts. The regulation's aim is and has always been to ensure, firstly, accountability and secondly, responsibility. The IBA Act, Mr. Speaker, sir, is 20 years old and has known several alterations over the years. As a responsible government, much like we did with the Cybercrime and Cybersecurity Act, we are merely improving the law. These changes are necessary and courageous, and we can only congratulate the Prime Minister for having the courage, the determination to modernize the country. And in this pandemic period, when we are facing so much challenges, I'm not trying to better the Prime Minister, but it's a blessing that we have today Pravin Kumar Jagannath as Prime Minister of this country, you like it or not. People demonstrating out there on a parliament day, when parliament is sitting. Mr. Speaker, sir, this Prime Minister has not sent out SSU and then, like some did, with lady workers claiming for their right, and then come and say, SSU pan faire pour don biberon. Indeed, there are twisted alternative facts that we need to protect our citizens from. I can only guess they are referring to the new clause 18A, which will allow the director of IBA to obtain an order from a judge in chamber to obtain from a person evidence, record, document, or article that will help in an inquiry of the authority. This is because I fail to understand why some would suggest we are, for example, trying to force a journalist to reveal his or her source of information. Monsieur le Président, il faut bien comprendre. Le journaliste n'est pas partie de la procédure administrative qui concerne la direction de la radio. Disclose the evidence required, c'est dans le cadre d'une procédure disciplinaire qui concerne l'administration, le détenteur de la licence, pas les journalistes. Now, Mr. Speaker, sir, for the sake of our democracy, I hope that any journalist worth his salt should at least have proof of what they are broadcasting as news on radios or on television. That they have fact-checked their information before committing it to our fellow countrymen. Because if news is being shared to the public based only on hearsay, then there is a fat chance that the information to be broadcasted is not 100% true and is not 100% reliable. It is extremely unethical and dangerous. Now, if the proper procedure of gathering of information is followed, evidence is crucial in any article. The question of the source does not even arise. It is a question of proof, Mr. Speaker, sir. Just like one Monsieur Kontu, who was involved in Heritage City. There was one advisor at that time at the PMO who had a document, who said he had a document about Heritage City. And what did that man do? he went to IBA asking to fact-check if the document is real or not. That's only fair, Mr. Speaker, sir. I cannot just come and brandish any sort of paper. I have got a document, give it to a journalist, he go out and spoil the name of anyone, and I can't come and challenge that document. I'm not asking you, this law is not asking for the source. It's not asking Mr. X, Mr. Y gave that document. But at least, if you are credible, prove the document, give the document. Just like if I go in here mentioning a document, you will also to table the document because you want to check from where I'm quoting. That's only fair, Mr. Speaker, sir. Et pour rassurer nos amis les journalistes, Monsieur le Président, c'est important qu'ils comprennent qu'ils sont protégés par le Data Protection Act. Ils ne seront pas appelés à divulguer leurs sources comme veulent faire croire certains membres de l'opposition ou d'autres oiseaux de mauvais augure. C'est important que je me répète. L'IBA ne détient aucun pouvoir de demander à un journaliste de divulguer ses sources d'information ou encore moins le nom de ses contacts. Moreover, it will up to a judge in chamber to determine whether or not any documentary evidence is crucial to the inquiry of the authority. Une fois encore, Monsieur le Président, on est en train de nous diaboliser quand nous sommes simplement en train d'essayer de responsabiliser et surtout de protéger le citoyen lambda. Private radios have been part of our wavelength since 2002. We are on the eve of the 20 years of existence, but we are yet to see a common self-regulating code de déontologie from the operators. Therefore, it is important to have at least an ethic guideline which will help keep in check any abuse or misinformation. I see some journalists have brandished their own code of ethics on social media, as if to say, I already have one. Well, have you been using it? I'm not so sure, Mr. Speaker, sir. This amendment provides a framework for a uniform ethical guideline. Another discord we can hear from the opposition is a section of the press, is the validity of the license passing from 3 years to 1 year. Firstly, it is an important administrative measure, Mr. Speaker, sir, to avoid situations where a radio is unable to operate midway through the licensing period and hold back wavelengths that could have been allocated to another operator. We all know that this has occurred in a recent past. My honorable colleague Dulab already spoke about that. Moreover, as far as I'm aware, the license is still being paid on a yearly basis. So what difference does it make to bring its validity to a year? You pay your license every year, but you don't want it to be valid for a year. So it doesn't make much sense. It's merely an administrative issue, comme on dirait un tempête dans un verre d'eau. I heard some claim that they will not be eligible to bank loans. Well, banks, I think it's obvious, base themselves on your repayment capacity when they're gonna give you a loan. Why would the period of validity then matter? Every other business has to renew the license every year. Does that mean those businesses are not eligible for loans? Pure nonsense, Mr. Speaker, sir. What they do not tell you is that all the radio already renew their license every year for the past 20 years because, Mr. Speaker, sir, they choose it to do it that way themselves. So why the fuss if we're making it official? What are they really afraid about? Coming to clause 29A, Mr. Speaker, sir, I believe it is more explicit, detailed, precise process whereby disciplinary proceedings can take place to allow any citizen aggrieved by a broadcaster to seek redress. It also details the process by which the licensee can have representations to defend and challenge any decisions of the authority. The Independent Broadcasting Review Panel will provide another remedy to licensee if they are still not agreeable to any decision made by the authority. The ultimate recourse remains the Supreme Court. This goes one step further as compared to the existing law. J'ai entendu, Monsieur le Président, des avocats de carrière dire que le Independent Broadcasting Review Panel aura pratiquement le rôle d'un juge en chambre. Non, quand il y a là un rôle purement disciplinaire et non pénal, au terme d'une procédure disciplinaire qui relève d'une négociation. De plus, les proceedings du Independent Broadcasting Review Panel doivent être publics, sauf pour des cas exceptionnels selon la section 30G subsection 1. Mr. Speaker, sir, this is very far from being an attempt to oppress radios. On the contrary, il ne faut pas avoir la mémoire courte. Malgré tout ce qu'on vous dit de l'autre côté de la Chambre, la libéralisation des ondes, c'est le MSM. C'est aussi le MSM qui a redonné vie au Media Trust, une institution qui est en train de former nos journalistes depuis 2015. Et avant 2015, c'était dormant, ça n'existait même pas. Private radios have been decisive in the progress of society over the past 2 decades. Listening to radios at every hour, day and night, is deeply etched in Mauritian culture. We have no intention to disrupt this trend, but we want to make it reliable. This law is 20 years old and needs improvement. We are merely preparing our country and media space for the future. Radios, in particular, play an important role in informing, educating, and entertaining our population. This is an enormous responsibility, Mr. Speaker, sir. And as a responsible government, we have to put in place the proper guardrails wherever appropriate to ensure there is no dérive or dérapage, or even financial malpractices under the cover of freedom of expression. Some will have to explain. How is it you have no money in bank, you are making losses, but you are still paying your employees? Who paying? Where that money comes from? I don't think my good friend, Honorable Siratan, wants to go and explain that to FATF again.
Try to conclude.
Monsieur le Président, quand il s'agit des lois qui sont dans l'intérêt public, le bon sens doit prévaloir. Il y a des tentatives de faire croire qu'on souhaite persécuter tel ou tel média, que ce gouvernement veut serrer la vis aux radios. Rien de plus farfelu, Monsieur le Président. I'll try to conclude rapidly. But us on this side of the House, Mr. Speaker, sir, we are not the evil one, nor are we the one who are oppressing. We don't have any hidden agenda. Personally, I believe the uproar of certain licensees has nothing, absolutely nothing to do with freedom of expression. The main concern is a fine going from 100,000 to 500,000. Well, that also has already been canvassed by my good friend Kabi Dulab. And yesterday we also had some lawyers, one lawyer particularly, claiming to represent the private radios pro bono to challenge this bill. I'll invite the lawyers from the other side of the House to join in so as we can really put the bill to test in a court of justice. But my advice to the radios will be, attention, Boma Sekutsea. Thank you, Mr. Speaker, sir.
Honourable Prime Minister. Monsieur le Président, laissez-moi tout d'abord commenter sur le cinéma de l'honorable Arvin Boulel aujourd'hui. L'honorable Arvin Boulel était suspendu de la Chambre jusqu'à vendredi 19 novembre 2021. Il aurait pu regagner son siège pour le sitting du mardi 23 novembre 2021. Le mardi 23 novembre, il est absent. Il ne vient pas à la Chambre. Et pourtant, Monsieur le Président, il a entré une affaire en cours for whatever relief he is seeking before the court, the case is before the court, but at the end of the day, he was contesting his suspension, meaning that he wanted to be able to be in this house so that he could represent his constituency and people generally, to do his work. Quand il n'est plus suspendu, il choisit de ne pas venir dans la Chambre. Mais en plus, ce n'est pas seulement mardi le 23 novembre, on siège vendredi le 26 novembre, où la liste, bien sûr à l'agenda des travaux parlementaires, il y a le Independent Broadcasting Authority Amendment Bill. Il donne son nom comme intervenant. La liste est préparée en collaboration avec les deux whips et son nom y figure sur cette liste. Bien. On s'attendait, même qu'il n'était pas présent vendredi à 3 heures, on s'attendait que l'honorable Arvin Boulel allait venir, probablement, je pense qu'il est un peu fatigué, il doit se reposer, et peut-être arriver à l'heure où il devait intervenir. Je crois qu'ici, de notre côté en tout cas, on s'attendait à voir l'honorable Arvin Boulel faire son apparition, comme il a fait aujourd'hui avec les applaudissements de l'opposition. Arrivé son tour, Monsieur le Président, il ne vient pas. D'ailleurs, il n'est jamais venu le vendredi 26 novembre 2021. Et puis, enfin, je ne sais pas s'il passait du bon temps ailleurs. Et aujourd'hui, Monsieur le Président, aujourd'hui, il conteste maintenant. Lorsqu'il a perdu son tour, aujourd'hui, il vient pour contester et pour dire « je dois intervenir ». Et, Monsieur le Président, enfin, ce n'est pas une justification, mais encore est-il, cette opposition qui se réclame d'être transparent, qui se réclame de dire des vérités. J'aurais espéré au moins que l'honorable Boulel aurait dit pour quelle raison il n'est pas venu à 2 sittings de la Chambre. Non. Bon, d'après mes renseignements, je crois, il faisait son lune de miel. Mais tant mieux pour lui. Mais, Monsieur le Président, ce cinéma-là, ce cinéma aujourd'hui, que l'opposition, et tous les membres de l'opposition, vous pouvez regarder, peut-être, je ne sais pas si le public, la population peut voir, tous les membres de l'opposition ont suivi l'honorable Boulel dans sa protestation aujourd'hui. Voilà quel genre d'opposition nous avons. Ben, en tout cas, Monsieur le Président, nous avons un travail sérieux. Et je peux comprendre aussi que c'est la démocratie. Il y a ceux qui ne sont pas d'accord avec un tel projet de loi, c'est leur droit. Mais venez vous exprimer ici, et surtout quand vous avez votre tour, vous sautez votre tour, et vous commencez à faire un cinéma de très mauvais goût, je dirais. Hein? Mr. Speaker, sir, let me thank all the honourable members who have taken the floor and contributed to the debate on this bill. Mr. Speaker, sir, as I explained in my second reading speech on Friday last, the only objective of this bill is to revisit and revamp the legislation regulating the broadcast media so as to enable the broadcast regulator to discharge its mandate more effectively in a fast-changing media landscape. Mr. Speaker, sir, members from the opposing side have raised great hue and cry over this bill, both inside and outside the House. They have made all sorts of accusations and unwarranted vilifications of government's intention behind this bill. And I have been listening to them very carefully. And I must say that they have only been playing petty politics, as their arguments are not only untenable, but they also betray their bad faith. Their agenda is simply and merely to oppose for the sake of opposing. Anyway, members from this side of the House have already rebutted, in fact, most of their arguments. Nevertheless, Mr. Speaker, sir, I would like to respond to points which were raised by some members of the other side of the House, as there is a need to set the record straight and to dispel the confusion that they have knowingly and deliberately created in the minds of our citizens. Mr. Speaker, sir, let me first take the issue of administrative penalty. Although I expatiated lengthily on this on Friday last, citing several examples of similar provisions in foreign jurisdictions, we have heard several members from the opposition criticizing this proposal to empower the IBA to impose administrative penalties. They have alleged, following their superficial and tenuous reckoning, that this proposal will suffocate and put to silence the private radios. Honorable Utim, as usual, even tried to make believe very surreptitiously that the fine will be 500,000 rupees in all cases, irrespective of the nature and gravity of the offence. As a lawyer myself, Mr. Speaker, sir, I was expecting cogent interventions from lawyers on the other side of the House. But I was baffled by their blatant demagogy and cheap politicking. The law is crystal clear. And this has been said again today by the two previous interveners. The fine which may be imposed ranges, in fact, from, if I can say, 1 rupee to 500,000 rupees. The proposed new clause 29(5) of the bill provides that an administrative penalty imposed under this act shall not exceed 500,000 rupees. And Honorable Utim and others were so engrossed in their negative and political stance that they missed it completely, or shall I say that they deliberately chose to ignore it. Mr. Speaker, sir, Sections 25 and 26 of the existing IBA Act allow the authority to suspend or revoke a license, which in a sense is a more drastic measure whereby the licensee would not be able to operate at all. The proposed new mechanism of an administrative penalty, which shall be in monetary terms, can in fact be a more lenient sanction as compared to the existing sanctions, which are revocation, variation, or suspension of license. Administrative penalties will in fact increase the range of sanctions that are available to the authority and will, in fit and proper case, be used as a substitute for suspension and allow the radio to continue its operation. It would defy logic if licensees would prefer their license to be suspended rather than be given an administrative penalty which they can challenge before the review panel and the Supreme Court. Mr. Speaker, sir, as I said previously, the concept of administrative penalty is not new in our jurisdiction. It already exists in our body of law, for example, in the Bank of Mauritius Act and in the Financial Services Act. There are also a number of bodies that can themselves decide on a sanction. For example, a few examples are the Medical Council, the Professional Architects Council, and the Pharmacy Council. Mr. Speaker, sir, in any event, any decision of the IBA to impose an administrative penalty can be reviewed by a review panel, and that decision of the review panel may itself be challenged before the Supreme Court by way of judicial review as provided for under Clause 30L of the bill. Mr. Speaker, sir, it has also been argued that the upper limit of the penalty is too high. The amount of the penalty needs to be put into perspective on the turnover of a radio. And according to official figures, the highest turnover of the financial year ending June 2019 was 125,478,964 rupees. It is also important to highlight again that the maximum quantum of the administrative penalty that may be imposed is 500,000 rupees. And the operative word here is maximum, which of course Honorable Utim deliberately and conveniently chose to omit. Mr. Speaker, sir, the principle of proportionality pervades our jurisprudence, and any penalty imposed must reflect the gravity of the breach committed by the licensee. If the administrative penalty imposed is disproportionate, the review panel and of course the Supreme Court will provide justified redress. So far, the power to impose administrative penalties has not been successfully challenged before the Supreme Court. In any case, in this bill, as I said earlier, the power to impose such penalties is subject to a review mechanism. There is not only the review panel, but also the possibility of seeking judicial redress at the Supreme Court by way of judicial review. Therefore, the bill provides for adequate inbuilt safeguards in this respect. Mr. Speaker, sir, several honorable members from the other side of the House have, during their interventions, insinuated that this government has a hidden agenda and that administrative penalties is being introduced by the government as a further means to museler les radios privées. Mr. Speaker, sir, in order to debunk their falsehood, I would like to inform the House that an attempt had been made in 2007 by the then Prime Minister, Dr. Navin Chandra Ramgoolam, to amend the IBA Act to inter alia empower the IBA to impose what was then called administrative pecuniary penalties. In fact, a draft bill had already been prepared. The bill aimed at creating a new independent compliance institution called the Broadcasting Compliance Committee, which would replace the existing Compliance Committee with enhanced powers, generally to take remedial measures and to order payment of administrative fines in cases of breach of broadcasting licenses, code of conduct, code of ethics, and code of advertising practice, as well as unfair treatment, infringement of privacy, vilification, amongst others. The Broadcasting Compliance Committee was being empowered to order a licensee to pay a financial penalty not exceeding 100,000 rupees at that time, or such other amount as may be prescribed. And this one is important, Mr. Speaker, sir. There was no provision for any appeal mechanism. The IBA Amendment Bill that had been prepared in 2007 made provisions for the appointment of the chairperson and members of the proposed Broadcasting Compliance Committee to be made by the Prime Minister. The bill also provided for the abolition of the existing Complaints Committee. And today, these same people are paradoxically and ironically giving lessons about democracy and protection of freedom of expression. Mr. Speaker, sir, like I always do, because I've found out about all what was in preparation at that time, and I'm going to table the document so that everybody will see. Mr. Speaker, sir, questions have also been raised by opposition members about the appointing procedure of the members of the proposed Broadcasting Review Panel, and also about its independence. Mr. Speaker, sir, these honorable members should have known better. There are so many appointments to constitutional and other statutory posts in the public sector that are made by the Prime Minister, or on the advice or after consultation with him, but this has not raised any issue about the independence of these institutions. Our Constitution is indeed replete with examples where the Prime Minister has a determining say in appointment to posts much more important in nature than the review panel, the Secretary to Cabinet, the Financial Secretary, the Commissioner of Police, and permanent secretaries are all appointed by the Public Service Commission or the Disciplined Forces Service Commission with the concurrence of the Prime Minister, which is mandatory in all these cases. The independence and impartiality of such appointees have never been called into question for that reason, except, as I say, probably for members of the opposition. And Mr. Speaker, sir, in the opposition, I'm happy that there is a former Prime Minister and so many other members of the opposition from the Labour Party, from the PMSD, who have been in government before. And have they ever questioned the fact that in all these cases I've mentioned, that why is it that the Prime Minister is appointing or is advising or is being consulted in terms of appointment? No. Never when they were in government. That was good. That was independent. And today, this is not independent. Le peuple n'est pas dupe, Monsieur le Président. And the nominations of the members of the review panel cannot therefore be said to be doubtful and partial for the mere reason that they are appointed by the Prime Minister. Mr. Speaker, sir, The IBA's constitution, as provided in Section 6 of the existing law, is a diverse one. The chairperson is appointed by the President after consultation with both the Prime Minister and the Leader of the Opposition. In the case of other regulators, the chairperson of the FSC, for example, is appointed by the Prime Minister only. The Governor of the Bank of Mauritius, who is appointed by the President on the recommendation of the Prime Minister. We also have the Director General of ICAC, who is appointed by the Prime Minister after consultation with the Leader of the Opposition. I must say, under the amended Section 19 of the Prevention of Corruption Act. And when was that introduced? In 2006. And what was this manner in which the Director General of ICAC was appointed at that time, prior to 2006? There was an appointment committee which was vested with the power to appoint the Director General. And we all know we had to get the concurrence of 3 people. So, the Labour Party, I don't think they are in a position to teach lesson, to give lesson with regard to independence in terms of nomination of people in certain position. And it is also apposite for me to mention that the chairperson of the proposed broadcasting review panel should possess the same qualification as a judge of the Supreme Court, that is, a barrister of not less than 5 years standing, and the 2 other members of the panel shall have wide experience in the field of broadcasting policy and media issues. Moreover, the bill further provides that the review panel shall, in the exercise of its functions, not be subject to the direction or control of any other person or authority, and that proceedings before the review panel shall be regulated in a manner which is consistent with the rules of natural justice and procedural fairness. Mr. Speaker, sir, no right-minded person would doubt or call into question the impartiality or independence of the review panel. And that is also subject at any time to review before the Supreme Court. So these people who are hearing and determining a case will be minded that eventually this matter can end up before the Supreme Court. A further safeguard is provided at clause 30L, as I say, which provides that any party which is dissatisfied with the decision of the review panel may apply to the Supreme Court for judicial review of the decision. And our jurisdiction is replete with examples of tribunals, review panels, whose decisions may be subsequently reviewed by the Supreme Court. This is an important bulwark against any sort of arbitrariness. It is also noteworthy that in line with the judgment of the case, because when I listen especially to Honorable Shakil Mohammed, okay, he's fine, he has decided to address and to intervene on this bill, especially on legal matters, from the legal aspect. So let me reply to him also. When we look at the case of Mauritius Breweries and the Commissioner of Income Tax, 1996 Supreme Court judgment at page 402. All the hearings of the review panel must be held in public so as to comply with section 10(8) of the Constitution, unless otherwise decided by the panel with the agreement of the parties. I also heard criticisms about the composition of the review panel, which is said to be smaller in size compared to the existing complaints committee. Mr. Speaker, sir, I did explain lengthily on Friday last the reasons behind the abolition of the Complaints Committee. And I'm not going to come back on that anymore. But I wish to point out that the review panel will have the possibility to co-opt persons with the required experience in the relevant field while dealing with any particular application for review, and any such co-opted person shall be deemed to be a member of the review panel for the purpose of that particular case. Mr. Speaker, sir, much has also been said about the proposed reduction in the duration of a radio license granted by the authority from 3 years to 1 year. It has been argued in this House that a reduction in the duration of the radio license from 3 to 1 year will have an adverse effect on business and investment in this sector, and this will seriously impact on the operation of the private radios and their employees. This argument is, to say the least, untenable and fallacious. Mr. Speaker, sir, I wish to highlight the fact that most of the operational licenses granted to operators by the different authorities are valid for a period of 1 year. Let me mention some examples of comparable licenses which are valid for 1 year only. Freeport certificates issued by EDB, 26 types of manufacturing retailer licenses issued by the Mauritius Revenue Authority, licenses issued by the Pharmacy Board to operate pharmaceutical manufacturing wholesale retail units. Can you imagine? Manufacturing, pharmaceutical manufacturing plants. Licenses to operate medical laboratory, private clinics. All licenses granted by the Ministry of Blue Economy, Marine Resources, Fisheries and Shipping. All licenses issued by the Ministry of Agro-Industry and Food Security. Dealer in imported second-hand motor vehicle license. License permit for scrap metal. Trade license for bunker fuel. Can you imagine what sort of investment one has to make for such kind of operation? License of discharge of effluent in a wastewater system. Almost all licenses permit authorization delivered by the Financial Services Commission. Private security service provider license issued by the Mauritius Police Force. All tourist enterprise licenses issued by the Tourism Authority. All licenses issued by the Mauritius Ports Authority. 22 licenses out of 23 issued by the Gambling Regulatory Authority. Motor vehicles dealers license, petrol service station license, conductor's license issued by the National Land Transport Authority. I can go on and on like this, Mr. Speaker, sir. All these businesses have been operating for so many years with a license which is renewable on a yearly basis. And there have not been any such case issues of predictability or investment or employment or career prospects in these sectors. Many of them relate to businesses which require, as I said, significantly much more capital investment compared to the radios. So I fail to see why such issues would arise in the radio broadcasting sector, as mentioned by members of the opposition. Mr. Speaker, sir, an automatic renewal of a license does not exist in law. It is for Parliament and for the authority to decide when a license ought to be renewed. If the IBA Act did not provide for 3 years renewal, of course the Interpretation and General Clauses Act would apply. And Section 37A provides as follows, I quote, where a license, permit or authority is issued under an enactment, it shall at all times be subject to such terms and conditions as may be imposed, whether at the time of issue or renewal or during its currency, unquote. Therefore, in laws, where the duration of a license is not prescribed, that condition may be changed any time by the person who issues the license. I said it also before, radio frequencies belong to the state, Mr. Speaker, sir, and are allocated by the state. Private radios, they are laboring under the misapprehension that once allocated, these frequencies belong to the licensees. This is not true. A licensee is not an owner, but is a person who is granted a permission to use a resource which belongs to the state. And it would seem that the opposition is of the opinion that licensees of the authority have become the owners of the frequencies allocated to them. In fact, the very word licensee indicates the fact that these persons have been granted a temporary permission to use the airwaves, which is a resource which belongs to the state. Mr. Speaker, sir, the free private radios in Mauritius have been operating for over 19 years now. And in accordance with their own application forms, they were expecting to make losses only for the first 3 to 4 years. After that period, they became and are still profitable. And it is known that one of them now owns a building in Central Port Louis. Another one has grown in size with many related companies and is probably bigger a business than the two other put together. It is also noteworthy that although radio frequencies are the property of the state, since 2001, the ICTA has not been charging any fee for allocating frequencies to radios. Mr. Speaker, sir, some speakers from the opposition also raised concern and wrongly accused the government of having hidden agenda over the proposal that for the renewal of the radio license, the authority will be taking into account any sanction imposed by the authority on a licensee and the past conduct of the licensee. This provision is important, Mr. Speaker, sir, especially in the light of the amount of fake news circulating worldwide. It is also important to bear in mind that while Section 12 of the Constitution provides for freedom of expression, such freedom is not absolute and is subject to limitations provided for in the same section. In the case of Oseni versus the state, 2016 Supreme Court judgment at page 501, it was stated that freedom of expression, which is guaranteed under our Constitution, constitutes one of the essential features of a democratic society. However, the exercise of such a right is not an absolute one, but is subject to limitations laid down in the Constitution itself, and which are designed to ensure that the exercise of such a right does not prejudice and is subject to respect for the rights and freedoms of others and the public interest. The same principles were reiterated in the case of Gordon Gentil and another against Dayal, 2012 Supreme Court judgment at page 144. And the court added that Section 12 does not give an absolute guarantee to the freedom of expression, even with respect to press coverage of matters of serious public concern. Mr. Speaker, sir, I believe it is fitting for me to quote here an extract of an article published in 5 Plus, Dimanche of 29 February 2004, which is of utmost relevance. In the said article, Maître Ashok Radhakisun, the then chair of the Independent Broadcasting Authority, and now one of the legal advisors of 2 private radios, stated the following, and I quote, "Nous pourrions aller très loin dans les sanctions s'il le faut," dit Ashok Radhakisun, président de l'IBA. Le Premier ministre, Paul Béranger, a été clair dans sa déclaration lors de sa conférence de presse hier. Les dérapages en direct sur les radios privées sont dangereux et inacceptables. Le président de l'IBA a tenu les mêmes propos envers les responsables des radios privées hier matin. Au point, a dit le Premier ministre, ou au Conseil des ministres, la question a été évoquée. Et je cite, « Nous nous sommes demandé si nous n'étions pas arrivés à un moment où il fallait bannir les émissions en direct sur les radios privées. La chose est dans le domaine du possible si les radios n'arrêtent pas avec leur dérapage. » La veille, vendredi, au cours du Conseil des ministres, le Premier ministre avait pris la décision de rencontrer bientôt les responsables des radios en compagnie des membres de l'IBA et du vice-premier ministre. 3 heures plus tôt, c'était au conseil d'administration de l'IBA de rencontrer les responsables des radios privées et un responsable de la MBC. Une rencontre qui a pris l'allure d'une mise en garde, à en croire la déclaration que nous a faite le président de l'IBA, Ashok Radhakrishnan. Je cite, « Nous avons tenu à rencontrer les responsables des radios car nous sommes consternés par certaines émissions en direct. Nous leur avons fait plusieurs propositions, surtout par rapport à certains dérapages sur les radios privées. Nous avons évoqué les couvertures de certains sujets sensibles car nous ne voulons pas arriver à une situation sociale intenable sur fond de haine raciale. Les menaces, cette fois, sont précises. À l'IBA, nous sommes disposés à agir. Nous pourrions aller très loin avec des sanctions s'il le fallait. Nous proposons dans un premier temps d'arrêter momentanément des émissions en direct jusqu'à ce qu'on arrive à trouver une solution. Nous avons fait aussi d'autres propositions, comme l'achat d'un équipement, le broadcast delay, qui permet d'avoir un recul entre 8 et 20 secondes s'agissant des émissions en direct. Les responsables des radios ont eu une approche responsable, affirme Ashok Radhakrishnan, qui revoit les responsables des radios privées demain au siège de l'ICTA, cette fois, pour écouter leurs propositions. Unquote. Réaction, Finlay Sales, Radio One, et je cite, « Il est inacceptable que l'IBA interdise les émissions en direct, qui sont la respiration même d'une radio privée, à moins d'empêcher celle-ci d'avoir une vocation de service public. Certaines radios ont certainement des dispositions à prendre pour éviter tout dérapage. À Radio One, nos auditeurs ont le sens de la responsabilité. Il appartient aux journalistes animateurs d'imposer les paramètres pour éviter les dérapages à l'antenne. Nous avons toujours dit à Radio One que la liberté de parole ne suppose pas la liberté de dire n'importe quoi. Et nos auditeurs responsables l'ont compris depuis très longtemps. Au-delà d'une solidarité ou d'un esprit coopératif, il est utile de préciser que Radio One est hostile à toute censure, mais que ceux qui sont coupables de dérapage doivent être sanctionnés. Réaction, Eshan Kodabax. Et je cite, « Nous avons écouté l'IBA. Maintenant, nous allons consulter nos hommes de loi. À la réunion du lundi à l'IBA, nous comptons faire des contre-propositions. Il ne faut pas que la liberté d'expression soit victime de cette situation de division et de subdivision de notre société, créée par les hommes politiques eux-mêmes à travers le communalisme scientifique. » Vous pouvez imaginer à qui il est en train d'adresser cela. Hein? Le débat démocratique doit continuer. Il ne faut pas détourner l'attention sur des sujets d'importance comme la réparation de la richesse économique, par exemple. Nous notons que depuis quelque temps déjà, M. Béranger conditionne l'opinion contre les radios privées, les éditorialistes et des caricaturistes. Lorsqu'on sait qu'il y a une loi restrictive en préparation, permettons-nous d'être méfiants à l'égard de la démarche du Premier ministre, c'est-à-dire de l'honorable Paul-Raymond Béranger. Réaction? Chris Conaille, Top FM. Il est tout à fait normal que chaque radio assume ses responsabilités selon le cahier des charges de l'IBA Act. C'est vrai qu'il est très difficile de savoir ce qui peut sortir d'une conversation lors d'une émission en direct. Il incombe aux responsables d'une radio de prendre des mesures nécessaires, surtout en ce qu'il s'agit des sujets qui peuvent toucher à la religion. Notre société est quand même fragile. Des sujets qui touchent à la stabilité de notre nation ne devraient pas faire l'objet d'émissions en direct. Au niveau de Top FM, nous avons pris des dispositions nécessaires à travers un système qui permet de passer les appels en léger différé. Et je comprends la réaction du Premier ministre qui réagit fermement lorsqu'il y a des atteintes quand on traite des sujets sensibles. Mr. Speaker, sir, in an article which appeared in Lebdo newspaper on 29 February 2004, it was reported that the then Prime Minister, Honorable Paul-Raymond Béranger, had stated the following on abuses by private radios, and I quote, it is in Creole, and I have to quote what it is. Comment on peut dire, c'est surtout une radio privée, fini dans un dérapage en direct, l'inacceptable, les dangereux, et à tel point qu'il dans le Conseil des ministres, en tant que Premier ministre responsable de law and order et de l'harmonie sociale dans le pays, mon fin pose la question si avec ça un dérapage là, nous pas fin arrive à un stade qu'au nom de l'harmonie sociale et du law and order, nous pouvons ban complètement ban émission en direct le ban radio privé. Nous fin considérer la chose. Et la chose encore dans le domaine de ma possibilité, c'est une radio privée pas pour saisir et arrêter avec de tels dérapages. Nous pouvons prendre en vie légale. Et en attendant, IBA fait une rencontre ban responsable de la radio de la MBC aujourd'hui. Le Conseil des ministres délègue moi-même et le vice-premier ministre pour nous rencontrer très vite ban responsable de 3 radios privées en début de semaine, de même que le président de l'IBA pour discuter de toute la question. Et on 15th of November 2013, in reply to a private notice question from Honorable Béranger on the introduction of private television, the then Prime Minister, Dr. Navin Chandra Ramgoolam, stated that we have to be careful on the content to be aired because, and I quote exactly what he said, we have seen what has happened with private radios. False news every day. Practically every day. No fairness. No impartiality. And to a further question from Honorable Béranger, then leader of the opposition, as to whether the Prime Minister's office was interfering in IBA matters and the issue of radio licenses, the then Prime Minister, Dr. Navin Chandra Ramgoolam, stated that he was not interfering in those matters. Otherwise, he would have closed all the private radios. This is Hansard. This is on record, Mr. Speaker, sir. In any case, as I say, I've quoted this just to remind them of what at one time Honorable Béranger, who was Prime Minister, he himself, he was subjected. I'm not criticizing, I'm not saying that he was not subjected to all this kind of situation. But one way, when he was Prime Minister, this is what happened. The other one, when he was Prime Minister, well, he's not in the House, but leader of the Labour Party, as former Prime Minister. This is the situation he was facing. Both of them. But today, they are in their position. Today, things have changed. Today, they have become the champion. They are the ones now defending all the dérapage and everything that can happen on these radios. Mr. Speaker, sir, in any case, as I say, should a licensee feel aggrieved by the decision of the authority not to renew its license, he may apply to the Supreme Court for a review of that decision by way of judicial review. And they are making a lot of hue and cry. You know, I have to respond to this because the debate has been that Top FM is being targeted, right? I am not the one to decide. It is for the IBA to decide. But let us assume, in fact, the license of Top FM is coming for review. But let us assume, as I say, je pèse bien mes mots là, c'est pas moi qui décide, mais allons supposer que l'IBA décide de ne pas renew the license. Now, forget about this law. Forget about this amendment we are bringing to the IBA Act. Let's talk about now itself, the situation. It is supposed to be renewed for 3 years. Let us assume that the possibility, IBA decides not to renew the license. What happens? What happens? That is why I am saying I have put forward all these arguments about in case, as I say, no, it's not Top FM. It's a way of regulating for all radios. Whenever one has been at fault, there is a possibility of a sanction which is of lesser gravity than to suspend the license or than to revoke the license altogether or not to renew when it comes for renewal. And they are complaining. And the radios are complaining. They are saying, no, let's stick to what is already available in the law, what is obtained in the law. So it is better for one to be suspended, maybe for some time, not to be able to broadcast, instead of having a penalty, a fine. It is better for a licensee, for his license to be revoked altogether, instead of having to pay a fine. Or it is better for a licensee, when it comes for renewal of the license, for his license not to be renewed, instead of paying a fine. In case of fault, I'm saying. There must be some logic. Mr. Speaker, sir, there has been also a huge outcry from the opposition about the supposed unconstitutionality of the bill and of its alleged repressive nature. In regard to the unconstitutionality of the bill, suffice it for me to remind that by virtue of Section 45(1) of the Constitution, Parliament may, subject to the Constitution, make laws for the peace, order, and good government of Mauritius. Therefore, under the principle of separation of powers, it is for Parliament to legislate, and it is for the court to interpret the law. And we are in a country where the rule of law prevails. Anyone who is dissatisfied with the decision may apply to the Supreme Court for constitutional redress. In this House, the expression unconstitutional is being, in fact, liberally used by the opposition, which in the same breath indirectly criticizes the Supreme Court. Some members incorrectly stated that we are legislating, as I say, against Top FM. And when they have Top FM have a case pending before the court, case of judicial review before the Supreme Court. Let me say, Mr. Speaker, sir, first of all, I speak as a lawyer. There is nothing in the Constitution which prevents the legislator to legislate when there are pending cases. Nothing. I think the little time I've practiced at the bar, I have not come across such a law or such a case. In fact, in the judicial review case Jiawudi and the Ministry of Industry and others, 2020 Supreme Court judgment at page 248. And in fact, this argument has been put forward by Honorable Mohammed. He himself, he appeared as counsel for the applicant in this case, for the appellant. Huh? Maybe he has forgotten the regulations which were being challenged by way of judicial review were revoked despite the fact that the case, listen to that, the case had already been heard and judgment was pending. And in that case, the Supreme Court found no issue with the fact that the legislator revoked regulations when judgment was pending. And the case was set aside, Mr. Speaker, sir. And it's good. Well, Honorable Mohammed is not here, but he will let me table it so that he can have a look. Maybe it will refresh his memory in the case in which he himself appeared. Mr. Speaker, sir, I must say that the point being made about the bill being unconstitutional is, to me, it is untenable, as none of them has indicated. Well, they say it is unconstitutional, which I have not seen any section or any provision of the Constitution which they have mentioned is being contravened. And by which clause and which clauses are contravening specifically the Constitution. The Supreme Court has provided for specific rules to challenge the constitutionality of any law, and the rules are very clear and state that specific provisions of the Constitution must be referred to when challenging the constitutionality of any law. In fact, the Supreme Court Constitutional Relief Rules 2000 is very clear on that. Well, I'm not trying to make as if there is a case already before the court. I'm not taking any point of law, but I am so tempted, from raising these issues, especially when I have heard all those lawyers from the other side, putting forward legal arguments. Mr. Speaker, sir, freedom of expression is a fundamental freedom protected by Sections 3 and 12 of the Constitution of Mauritius. And we all know that the media in Mauritius generally operates in a conducive environment, free of violence or coercion, with journalists free to exercise their profession. However, as the rule of law prevails, the media is subject to the general laws of Mauritius. And these include laws relating to criminal defamation, contempt of court, and the Independent Broadcasting Authority Act. The local media has always enjoyed a tradition of freedom and pluralism. There are at present more than 40 dailies, weeklies, fortnightlies, monthlies, in addition to the several online publications. As a matter of fact, the Government Information Service has been issuing press reporters' pass to journalists, photographers, reporters, editors, videographers, upon request by the chief editors of media organizations. And as at date, 478 such press cards have been issued to the written press, online papers, private radios, MBC TV, and to other press correspondents. And out of the 478 press cards, 86 have been issued to private radios. And yet, government is being accused to have an agenda to suppress the expression, the freedom of expression. People have access to the media to express their views and have unrestricted exposure to different viewpoints. There is no official or unofficial censorship of the press. There is also unrestricted access to the internet, which is widely used. In any case, the proposed amendments do not touch Section 12 of the Constitution. So I fail to understand how freedom of expression under the Constitution is being curtailed. They have been speaking about threat to freedom of expression in the course of parliamentary debate which is being telecast live. Mr. Speaker, sir, what a paradox. And do I need to remind them that private radios became a reality under the government led by Sir Anirudh Jagannath in 2001? And do I also to remind them that live telecast of the proceedings of the National Assembly is also an achievement of the MSM-led government? The House and the nation will also surely recall who postponed general elections in this country and who restored them in 1982. The people of this country also recall who in 2014 close this National Assembly for 9 months here to work on a new constitution and supposedly a power-sharing arrangement between two leaders. As I say, the Mauritian population is mature, intelligent, and politically astute as it has both in 2014 and 2019 clinically separated the wheat from the chaff. Mr. Speaker, sir, we have no lessons to learn from the Labour Party or the PMSD when it comes to democracy and freedom of expression. Mr. Speaker, sir, let me now come to the criticisms leveled by the opposition against the provisions of Clause 5 of the bill regarding the power being vested in the director of the IBA to obtain, through a judge in chambers, relevant information needed by the authority in the exercise of its statutory functions. But before coming to that, Mr. Speaker, sir, I would like to express my utter disappointment and resentment at the irresponsible tenor of the statement of the leader of the opposition in this House on Friday last, casting aspersion on the judiciary, which were totally out of order and which should be condemned. Let me remind him of the provision of Standing Order 45, and I quote, "The conduct of the President and the Vice President of the Republic, or the person performing the functions of the President's office, the Speaker, members of the Assembly, judges, members of statutory commissions, or other persons engaged in the administration of justice shall not be raised except upon a substantive motion moved for that purpose. And in any amendment, question to a minister or remarks in a debate dealing with any other subject, reference to the conduct of the persons aforesaid shall be out of order." Unquote. Mr. Speaker, sir, at this stage, I find it up to quote the judgment of Honorable Doma in the case of Sonak Nandani versus Le Mauricien Limited and others, 2013, Supreme Court judgment at page 5, where the learned judge, at paragraph 27, observed as follows in relation to protecting the integrity and reputation of our judiciary. I quote, "It serves no one to lynch the judiciary, but to assist in consolidating it, if with constructive criticism. As judges, we maintain a composure. We have to. We are bound by a droit de réserve et de retenue, not out of unconcern, but simply out of an expectation that right-minded people will realize what is right and protect what is their pillar institution from wild and unfair attacks. An impartial and independent judiciary belongs to the people. It is in the interest of people to ensure that any comment made against it is made responsibly. There is very little judicial officers who are able to do except by their own conduct and the quality of their decisions. They are helpless when unfair attacks rain upon them from outside, and a small island developing state is as vulnerable to being swamped by rumors and mass hysteria as by the climatic event of a tsunami." Unquote. Mr. Speaker, sir, I may not always agree with judicial decisions, but I have never and will never attack or undermine the judiciary. In case one does not agree with a decision, one has to exercise one's right of appeal, but one ought not to undermine our institutions for party politicking or other purposes. Unfortunately, on the other side, it would seem that only the people who agree slavishly or blindly with them are independent. If one happens to hold any contrary view to theirs, one is not independent for them. The Honourable Leader of the Opposition has callously used parliamentary immunity to attack the judiciary, while his son's electoral petition has been heard and judgment has been reserved. This follows attacks by the opposition on the Electoral Commissioner and the Electoral Supervisory Commission, and the latest installment in undermining the credibility in our institutions is the attack on the Independent Broadcasting Authority. The Honorable Leader of the Opposition blows hot and cold. In his speech, he stated that Top FM's alleged troubles started with a challenge it made by way of judicial review against the grant of 2 radio licenses by the Independent Broadcasting Authority in 2017. These 2 radios were allegedly close to government. However, the IBA revoked the license of Planet FM in 2020 without the licensee ever having had any previous regulatory issues with the authority. So I call upon opposition members to be responsible and fair in their criticisms and to show that they are not allergic to fair play. But as far as I'm concerned, let me say this loud and clear. I have more trust in our judiciary and other institutions than in this opposition. Since 2019, they are still desperate. And you know what is their only objective? What is their program, if I can say so? Is to overthrow. Overthrow, by all means, a democratically elected government. And I understand that their successive defeats and withdrawal of the electoral petitions are events that they are still having difficulties to come to terms with. Mr. Speaker, sir, I was saying that some members of the opposition have accused government of having ulterior motives behind the new power being conferred upon the IBA to obtain information for a judge in chambers. This provision is similar to the one in the Banking Act, whereby bank records can only be obtained upon application to a judge in chambers, if not provided voluntarily when requested by the authorities. And such powers to seek information before the judge in chambers are also provided in the Medical Council Act and the Dental Council Act. Mr. Speaker, sir, contrary to what the opposition wants to make believe, the proposed mechanism to obtain information by the IBA is in no way an attempt to gag the voice and the freedom of expression of our citizens. But it is important to bear in mind the dangers of misinformation and disinformation and the serious implications this may entail. The operative words in section 18A(1) are, and I quote, "for the exercise by the authority of its statutory functions." I have carefully perused the statutory functions of the IBA as well as the bill, and I found no link to journalists having to reveal their sources. And I challenge anyone from the opposition to enter a constitutional redress to try and argue this before the Supreme Court. Mr. Speaker, sir, let me illustrate what 2007 IBA Amendment Bill provided for in sharp contrast to this bill in relation to the powers of the authority to seek information. In Clause 22A, which was titled Renewal of License, Section 22A, subsection 2, read as follows, and I quote, "The authority may, for the purpose of deciding whether or not to renew the license, require from the applicant such information as it considers necessary," unquote. Mr. Speaker, sir, the opposition must acknowledge that the 2007 bill provided no judicial safeguard by way of the scrutiny of a judge in chambers and failed to limit the information which the authority could require from a licensee in the discharge of its statutory functions. We have in this bill, in Clause 18A, provided for safeguards. The proposed amendments, far from being a violation to the right of freedom of expression, as guaranteed by Section 12 of the Constitution, provide for a detailed mechanism under Clause 18A of the bill, whereby the director may make an application to the judge in chambers for an order directing a person to disclose the evidence required, and it is only where the latter is satisfied that the evidence, record, document, or article, the disclosure of which is sought, is bona fide required by the authority in the discharge of its statutory functions, that the judge in chambers will make an order. This requirement of bona fide, coupled with a control by the judge in chambers, is the hallmark of the rule of law in our country, so that any potential abuse or arbitrariness is removed from the equation. Further, the point raised by Honorable Shakil Mohammed regarding an application being made ex parte or inter partes is irrelevant, as the judge in chambers will assess the legality of the application before making any order. We know, we lawyers, we have currently been dealing with such kind of situations, and the judge, of course, knows how to weigh the evidence that is before the court in order to either to grant an order or not to grant an order. And I must say, Mr. Speaker, sir, that as a lawyer, Honorable Mohammed, he doesn't cease to surprise me. His argument that Section 22(4) of the bill breaches the separation of powers, to me, is also devoid of any substance. He seemed to miss out that Section 22(4) is subject to Section 22(6), which defines judicial process as follows, and I quote, "Judicial process does not include any order or direction by a court prohibiting the enforcement of the sanction," unquote. The bill therefore provides, under the proposed new sections 22(4) and 22(6), that any sanction may be stayed if there is pending judicial process. It has specifically been provided in the proposed new sections 22(4) and 22(6) that if there is an injunction or direction by the court prohibiting the enforcement of a sanction, such sanction may not be applied. This cunning attempt to read Section 22(4) in isolation by a law practitioner, Mr. Speaker, sir, is very disappointing. I must say, to say the least. Mr. Speaker, sir, the separation of powers has not been encroached upon by this bill, as any aggrieved licensee may seek an injunction to prohibit the enforcement of a sanction. Mr. Speaker, sir, what have we not heard from the other side of the House in relation to sections 22(4) and 22(6)? Let us see what was being provided in 2007 bill. Allow me to read Section 30B, subsection 3, and I quote, "An appeal under subsection 1A or B shall not have for effect a stay of the execution of the decision of the committee unless the Supreme Court or the judge in chambers, as the case may be, orders otherwise," unquote. Mr. Speaker, sir, this is exactly the type of mechanism that we are providing in this bill. Mr. Speaker, sir, the Leader of the Opposition and other members have stated that the bill is an ad hominem response targeted to persecute one particular radio, the license of which is yet to be renewed. Some basic legal principles have been ignored by members of the other side of the House. The first point about legislation which is enacted by Parliament is that such legislation is made pursuant to Section 45(1) of the Constitution, which provides that subject to this Constitution, Parliament may make laws for the peace, order, and good government of Mauritius. The second point is that pursuant to Section 5(7) of the Interpretation and General Clauses Act, and I quote, "The law shall be considered as always speaking, and where any matter or thing is expressed in the present tense, it shall be applied to the circumstances as they occur." To state that this law applies only to Top FM is tantamount to intellectual dishonesty. I wish for the record to highlight that the license of First Talk Limited, that is Waza FM, expires on 17 December 2021. If the license is renewed by the IBA, the one-year renewal will also apply to it if this bill is passed and comes into force. Therefore, as I say, it is intellectually dishonest to state that the reduction of the license term from 3 years to 1 year applies only to Top FM. Mr. Speaker, sir, in a judgment in the case of Fédération of Civil Service and other unions and others versus State of Mauritius, 2009 Supreme Court judgment at page 214, the Supreme Court had this to say, and I quote, "We must straightaway say that ad hominem legislation per se must not be struck down unless unconstitutional," unquote. However, the present bill is neither ad hominem as it applies to all licensees, nor is it unconstitutional. And by way of illustration, the case of Mahbub and the government of Mauritius, 1982, MR at page 135 is an example of ad hominem legislation which was unconstitutional as Parliament enacted a law to deprive a person of the outcome of his judgment, and such is not the case with this bill. These allegations, therefore, do not hold water and are also misconceived, inasmuch as the proposed amendments are designed to bring more transparency in the system by providing inter alia for the issue of a code of ethics, code of advertising practice, or such other code as the authority may determine, not for the sake of persecution or curbing the freedom of expression, but for bringing certainty in what sort of conduct is expected of all licensees and for the regulator to monitor their conduct. It is also highlighted that these codes already exist, and it is a condition of the license issued by the IBA to any licensee that they have to comply with the laws of Mauritius and the IBA Act and its codes. Mr. Speaker, sir, with regard to the criticism level against the proposed increase in the penalties for offences under the Act, I would like to say that there is also nothing sinister in increasing a penalty, either in terms of fine or imprisonment, if, of course, the situation so demands. It is to be noted that the new penalty is not a fixed one, meaning that it is only the maximum penalty imposed, and therefore, whatever penalty is to be given to a body will be proportionate to the gravity of the contravention. In any event, the fines provided are going to be subject to review by the courts. The legislator is only providing for maximum fines. It will be up to the courts to choose the appropriate fines, and in case any person is dissatisfied with any fine, he may appeal to the Supreme Court. Mr. Speaker, sir, we have had no meaningful contribution to the debates from the opposition, except empty rhetoric and blatant demagogy. They have wrongly accused government of having ulterior motives, arguing that the bill is targeted to one particular radio and that the government is trying to clamp down on freedom of expression and free speech, that the bill is unconstitutional, and so on. It is so obvious that this opposition has not been and is not at ease to see how this government has been transforming and modernizing the country in the national interest with a clear 2030 vision. Mr. Speaker, sir, these amendments to the IBA Act were long overdue, as evidenced by the fact that a similar bill had been drafted since 2007. As I have said previously, the IBA has an important role to play in maintaining a peaceful broadcasting environment by serving the best interests of all stakeholders in a fair, objective, and independent manner. And let me reassure the House that these amendments have as sole objective the revamping of the law so that it is tuned to present-day realities and exigencies and enables the IBA to discharge its mandate in a more efficient and effective manner. Thank you, Mr. Speaker.
So you commend the bill? And seconded. The question is that the Independent Broadcasting Authority Amendment Bill number 18 of 2021 be read a second time. Those in favor say aye, those against say no. The ayes have it. I think you... Committee stage.
Clause 1, short title. Clause 2, interpretation. Clause 3, section 2 of Principal Act amended. Clause 4, section 5 of Principal Act amended. Clause 5, new section 18A added to Principal Act. Clause 6, section 19 of Principal Act amended. Clause 7, section 22 of Principal Act amended. Clause 8, section 23A of Principal Act amended. Clause 9, part 5 of Principal Act repealed and replaced. Clause 10, section 31 of Principal Act amended. Clause 11, section 32 of Principal Act amended. Clause 12, section 33 repealed and replaced. Clause 13, section 34 of Principal Act amended. Clause 14, section 36 of Principal Act amended. Clause 15, section 37 of Principal Act amended. Clause 16, section 38 of Principal Act amended. Clause 17, first schedule to Principal Act amended. Clause 18, third schedule to Principal Act repealed and replaced. Clause 19, consequential amendment. Clause 20, transitional provisions and savings. Clause 21, commencement.
The question is that clauses 1 to 21 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Schedule.
The question is that schedules stand part of the bill. Those in favor say aye, those against say no.
Title enacting clause.
The question is the title and enacting clause stand part of the bill. Those in favor say aye, those against say no. Ayes have it. The question is that due report to the House, the Independent Broadcasting Authority Bill number 18 of 2021 has passed the committee stage without amendment. Those in favor say aye, those against say no. The ayes have it. Please be seated. Honourable members, I have to report to the House that the Independent Broadcasting Authority Amendment Bill number 18 of 2021 has passed the committee stage without amendment.
Third reading.
That the Independent Broadcasting Authority Amendment Bill number 18 of 2021 be read a third time and passed.
The question is that the Independent Broadcasting Authority Amendment Bill number 18 of 2021. Yes, let me first. Authority Amendment Bill of number 18 of 2021 be read the third time and passed.
Mr. Speaker, in terms of Standing Order 51, I would like to move for a division of votes. And I would also like, Mr. Speaker, in view of the possibility or the probability that the bill will be challenged as to constitutionality, that the division of votes be organized in such a way that each member votes individually so that we can see whether the 75%... What is the problem with these guys?
No.
What
Don't
is the
guide
problem?
the chair. Please.
Now, therefore, in view of the... I just finished? Of the probability that the bill will be challenged in court as to constitutionality, that each member votes individually so that we know whether the 75% threshold has or has not been reached.
So do you have a point of order?
It's not a point of order, it's a motion.
It's a motion, yeah. So yes, go ahead.
In addition to what the leader of the opposition has said, I specifically, to justify and to support what he has said, why a division of votes there should be. Am I allowed to speak or not?
But how can you?
But I'm not being allowed to speak, Mr. Speaker. Please.
Why? Please.
Section 8 of the Constitution, this particular bill has a direct consequence on Section 8 of the Constitution. And Section 8(4) of the Constitution specifically states that in situations of this nature where a substantial interest, which I equate with property, is in fact involved, as far as deprivation of property is concerned, there is the need for a 3/4 majority to be obtained for it to pass. That is why I also concur with the Honourable Leader of the Opposition that a division of votes should be requested, and why it is important, in line with Section 8(4) of the Constitution, that the division of votes be asked for.
So Section 51(2), if the Speaker is of opinion that a division is unnecessarily claimed, he may, as soon as the bells cease to ring, take the votes of the Assembly as follows. Those who support, those who do not support. Allow the clerk to ring the bell. Those who support my decision, rise in your places, please. So the majority is obvious. Order! 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 Honorable Patrick Asiabaden, I order you out. Please be seated. So, Clerk, could you please proceed? Finally, that the Independent Broadcasting Authority Amendment Bill number 18 of 2021 be read the third time and passed. Those in favour say aye. Those against have it. So, Clerk.
Public Bill, second reading.
Honourable members, I'll suspend the sitting for 1 hour.